Good morning, everybody. The time is 10:05. I call the May 18th, 2023 Planning Board meeting to order. We are joined by a full complement today. We have Vice Chair Bailey. We have Commissioner Washington, Commissioner Dorner, and Commissioner Giraldo.
Good morning.
I'm Chair Shapiro. And on to the business at hand. Please note that the deadline for all participant pre-registration and for all submission of materials and exhibits was 12 noon on the Tuesday before this planning board meeting. Registered speakers may join the meeting with the link provided in the email, which is provided by the planning board office, or listen by phone by utilizing the call-in number provided in the email as well. Of course, anyone may tune in to watch the planning board meeting via live stream. And if you wish to speak or become a person of record, you may use our online web form, which you'll see referenced on the screen before you. In addition to the commissioners, we are joined by our principal counsel, David Warner. We have Jessica Jones, our planning board administrator, with us. We have Joe Parsons, our senior technical hearing writer, James Hunt, the division chief for the Development Review Division. And we have staff members Kenneth Flanagan and Dan Hartman, who are helping us with technology behind the scenes quite ably, as always. Thank you very much. So we will move on to our first item on the agenda. We have resolutions of appreciation. Let me start with the resolution to support Preservation Month. This year marks the 50 years of celebrating during the month of May. Preservation Month, a collaborative work at local, state, and national levels to promote historic places and heritage tourism, to spotlight the diverse and unique heritage our countries, cities, and states have, and to demonstrate the social and economic benefits of historic preservation and revitalizing our communities and reinvesting in our futures. Next Thursday, May 25th, the annual Prince George's County Historic Preservation Reception will take place at our facility, Oxon Hill Manor, where we will celebrate the shared work of the Prince George's County, the Office of the County Executive, County's Historic Preservation Commission, our Planning Department, our Department of Parks and Recreation, numerous local organizations, agencies, civic groups, and residents. So it is exciting to see. And so before us is the resolution in support of Preservation Month, and I would look for a motion to approve the resolution.
So move.
Second.
We've got a motion by Commissioner Giraldo, a second by Vice Chair Bailey. Discussion on the motion. Seeing none, I'll call the roll. Commissioner Giraldo.
I vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. Next, we have a resolution of appreciation for a recently retired member of our team, Lieutenant Cody Evans. Cody Evans served 23 years as a law enforcement officer with our Maryland National Capital Park Police in both Montgomery and Prince George's County. Has held various roles and earned multiple promotions: patrol officer, police activities league officer, field training officer, canine handler and canine sergeant, patrol sergeant, patrol lieutenant. He was instrumental in the creation of the Park Police Canine Unit within the Prince George's County Division. We thank Lieutenant Evans for his contribution to the commission, and we wish him a very happy retirement. And we have a resolution before us. And unless there's any questions or comments, I would look for a motion to approve the resolution of appreciation for Lieutenant Cody Evans.
Approve resolution of appreciation.
Second.
Got a motion by Vice Chair Bailey, a second by Commissioner Giraldo. Discussion on the motion. Seeing none, I'll call the roll. Vice Chair Bailey.
Vote aye.
Commissioner Giraldo.
I vote aye.
Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. Thank you very much, Lieutenant. Next, I'll look for a motion to approve the draft minutes of May 4th, 2023.
Motion to approve draft minutes of May 4th.
Second.
We had a finger from Commissioner Giraldo, but a voice from Commissioner Washington.
We work in tandem.
It was a good team
I just
effort.
assumed he was pointing to me, so.
Oh, I didn't think about that. That's true. Okay.
It's true. The motion was Vice Chair Bailey. The second was Commissioner Washington, as authorized by Commissioner Giraldo. I will call the roll. Vice Chair Bailey.
Vote aye.
Commissioner Washington.
I vote aye.
Commissioner Giraldo.
I vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 5-0. Next, excuse me, Commissioners. Next item on our agenda is executive session. Let me read the statement, the closing statement, before I look for a motion. So there are going to be two reasons why we're going to executive session. First, pursuant to the general provisions article of the annotated code of Maryland, Article 3-305, subsection B3, a closed session is proposed to discuss the acquisition of real property for a public purpose and matters related thereto, and for the purpose of protecting the Commission's negotiating position, and pursuant to the general provisions article of the annotated code of Maryland, section 3035B7, go into executive session in order to protect applicable privileges, to consult with counsel on legal issues related to board actions. So that is the reason why we're going to executive session, and I would look for a motion to that effect.
Motion to go into executive session.
Second.
Got a motion by Vice Chair Bailey, a second by Commissioner Washington. Discussion on the motion. Call the roll. Vice Chair Bailey.
Vote aye.
Commissioner Washington.
Vote aye.
Commissioner Giraldo.
I vote aye.
Commissioner Dorner.
Aye.
I vote aye as well. The ayes have it 5-0. I will see you all in executive session, and to the public, we will likely be back in open session in about 15 minutes. Thanks.
Okay.
Kenny, are we live again?
Yeah.
All right. We're recording again? Yeah. All right. Folks, we are back in open session. Let's give a minute or so for our fellow commissioners to join in. All right, just give just one more minute for Vice Chair Bailey, and we'll get started. Okay, why don't we continue in the process, and Vice Chair Bailey would join us in just a minute or two, I'm sure. So first thing, just want to announce that the board, in closed session, the board received briefings and direction was given to staff on the matters that we discussed for the reasons that we discussed when we went into closed session. Next item on our agenda is the consent agenda. Is there anyone who wishes to oppose staff's recommendation? Any board member or anyone from the public wishes to oppose staff's recommendations on item 4B, C, or D? And if not, then I'd look for a motion to approve the consent agenda.
Mr. Chairman, after consideration of the record for items numbers 4B, 4C, and 4D, I move adoption of staff findings and approval of the items on the consent agenda in accordance with the recommendation of staff.
Second.
Got a motion by Commissioner Washington, a second by Commissioner Giraldo. Discussion on the motion. Seeing none, I'll call the roll. Commissioner Washington.
I vote aye.
Commissioner Giraldo.
I vote aye.
Commissioner Dorner.
Aye.
I vote aye as well. The ayes have it 4-0. 4-0. Let's give it one more minute before we kick into item 5. Hold on one sec. Okay. All right. Staff is communicating with Vice Chair Bailey. She's asking us to continue, and she'll work through her technical issues. So let's pick up item 5. Item 5 is detailed site plan DSP 22023. It's 7010 Greenbelt Road, Greenbelt Square. Mr. Haller is the representing the applicant. Ms. Lockhart will give the staff presentation. The planning board, for this case, the planning board will be conducting an evidentiary hearing. So we are requiring those intending to provide testimony to take an oath. So at this time, I ask all persons intending to provide testimony to come on screen if you can, and to raise your right hand while I swear you in. Okay, do you solemnly swear or affirm that your testimony will be the whole truth and nothing but the truth?
I do.
I do.
Okay, consider yourself sworn in. And we'll now turn to Ms. Lockhart for the staff presentation, and then we'll hear from Mr. Haller. Ms. Lockhart, good morning, and take it away.
Okay. Good morning, Mr. Chair and members of the board. For the record, I am Dominique Lockhart with the zoning section. Item number 5 on the agenda is detailed site plan DSP-22023 titled Greenbelt Square, which proposes development of 95 age-restricted multifamily condominium units. The applicant, along with the city of Greenbelt, have provided recommended conditions as part of their exhibits, which is included in the additional backup. Staff has reviewed the revisions and is in agreement with majority of the proposed conditions. Staff has provided a memo also included in the additional backup, proposing minor changes to conditions 1DD, 2I, 2J, 3A, and 4. The applicant and city are in agreement with the conditions as revised by staff. Staff also agrees with the applicant's remaining proposed conditions as provided in the backup. Based on the findings presented in the technical staff report, staff recommends that the planning board approve detailed site plan DSP-22023 and associated type 2 tree conservation plan TCP2-009-2023, subject to the conditions as revised by staff. This concludes staff's presentation. Thank you.
Thank you, Ms. Lockhart. Questions for staff before we hear from the applicant? Pretty straightforward case, but still. Okay, Mr. Haller, turn to you.
Thank you, Mr. Chairman. Good morning, members of the planning board. Thomas Haller, an attorney's offices in Largo, on behalf of the owner of the property and the applicant, Armory Square LLC. I'm really excited to present this case to you today, and I'm going to take a little bit longer than I probably should for what should be a fairly straightforward case. Just because of the history that I wanted to share with the planning board. I do have with me today Mr. Ian Black, who is a representative of the ownership group, and Sylvia Silverman, who is with our engineer. But just to put this project into perspective, this property was acquired by Armory Square back in 2005. And at the time they acquired the property, it was improved with a vacant nursing home, which was constructed in the late 1960s. They had a development plan at the time, which was to construct an apartment building with structured parking, basically a wrap, if you will, with a precast garage. And that plan was approved back in 2006. Unfortunately, shortly after the plan was approved, the recession hit and the plan became unbuildable because of the cost of building the structured parking. And so in the intervening 17 years, we have been working to find an alternate development proposal for this property. Now, when we went through the original development approval process, we worked closely with the city of Greenbelt and they supported the plan, but we also agreed to enter into a declaration of covenants with the city, pursuant to which we agreed to give them approval authority over the site plan in addition to the planning board's approval authority. And so they have truly become our partners in trying to figure out how to best use this property. And over the course of time, we brought them several development proposals for them to evaluate. And what they have consistently told us over the past several years is that they want a project that is age restricted, for sale, single floor living, because that is a product that the city of Greenbelt does not have. They also asked us and urged us to deliver a project which is attainable from a price standpoint to give existing residents in the city of Greenbelt the ability to stay in the city as they age, should they want to move to something that is elevator served and one floor. Fortunately, NV Ryan has developed exactly that product and has been very successful with it in other markets in Virginia and elsewhere. Each one of these buildings is 4 stories. Each is designed with 24 units, and each one is served by an elevator. The city did ask that one of the units be converted to a community meeting space so that the residents would have a place to have condominium association meetings and whatnot. So the total number of units that you see before you proposed is 95 units, and all of the units are 2-bedroom. In addition to the community room, we are providing a low impact exercise area outside, sitting areas, a pavilion, a community garden, and a pickleball court, which should be very popular with an over 55 community. We have, and staff indicated this, we had no issues with any of your staff's recommended conditions. The revised conditions that we submitted were solely intended to incorporate the conditions that were recommended by the city of Greenbelt. You have a letter in the record from them dated May 8th, 2023. As I said, this has become a true partnership with the city. They have made several recommendations, which we have fully agreed to, and those recommendations have been incorporated into the staff's conditions. Staff did have a few tweaks to those conditions, which are in their updated memo, just to reword some of them to make sure that they conform to the standard forms that we typically see in front of the planning board. So with that, we are in full agreement with the staff recommendation, subject to the revised conditions to incorporate the city of Greenbelt's recommended conditions. And we are happy to answer any questions that you have about this project.
Thank you, Mr. Haller. Commissioners, any questions for Mr. Haller before we turn to the representative of the city of Greenbelt and the rest of the time to speak?
I have
Commissioner
just,
Gerald?
yeah, I have a few, I'm sorry. So, Mr. Haller, I see, do you think, or did the city agree as well that only 2 electric charging stations are sufficient? And I'm thinking
Well,
more.
actually, one of the that's a good question, Commissioner. The city's conditions, they asked us to do more than that. And so what we've done is we have done 2 things. We are providing an electrical vehicle charging station in front of each of the 4 buildings, but we're also installing the infrastructure so that as demand for electric vehicles grows, the infrastructure will already be there. It'll be easy for the condominium association to add additional charging stations.
Okay, great. And my other question is, I didn't see it in the plan, but I may have overlooked it. Are you going to put any dog waste stations for the residents?
We are. That's also a condition that the city asked us to supplement as well. So we do have a condition in the additional backup that to provide the dog waste stations.
Okay. Thank you, Mr. Haller. I have no further questions, Mr. Chair.
Thank you, Commissioner. Commissioners, any other questions for Mr. Haller at this point? All right, let me just say that, and we'll hear from the city of Greenbelt too, but it is very nice to see, first of all, it's a quality project, but it's also very nice to see the close collaboration between the applicant, our staff, the city of Greenbelt, I appreciate the all the smoothness to the process. So let me turn to the,
Mr. Chair,
yes,
David Warner, Principal Counsel, if I can just interrupt for one quick procedural question for Mr. Haller.
Yes.
Um, he represented in his testimony that the applicant is Armory Square. We're showing that it's Armory Place.
I apologize.
Those are two different entities,
Greenbelt
two
Square,
different
I'm sorry.
principal office. Is it Armory Square?
No, it is Armory Place. Excuse me, it's Greenbelt Square is the name of the project, and it's Armory Place is the name of the owner. I got the two confused.
Okay.
I apologize.
No problem. Thank you.
thank you, Mr. Warner. So let me turn to the one person who signed up to speak. We have the representative from the city of Greenbelt. If you could introduce yourself for the record and take your time to let us know what you think.
Yes, good morning, Chair, members of the board. For the record, Terry Ruby, Director of Planning and Community Development for Greenbelt, here speaking on behalf of the city. The city is in agreement with your staff's recommendation as revised, and I want to thank them and the applicant for working with the city to address our concerns. As Mr. Haller alluded to, this has been years in the making. It involved numerous staff level conversations, numerous advisory board meetings and council meetings. And thanks to their willingness to listen and to respond to the city's questions and concerns, we now have a project that we can conditionally support and that we're very excited for. This will be the first age-restricted condominium development in the city, and we believe it'll provide expanded housing opportunities for our aging residents as well as those in the county as a whole. To give you a little perspective, Greenbelt is over 55% multifamily housing. We only have less than a handful that are served by elevators. And we have an aging population who has voiced continuously the need for us to look at housing opportunities that allow them to age in our place. And we're hoping this is one of many. We're hoping soon we'll be able to bring an affordable one to you as well. But we're very excited to see this project come to fruition. And I want to just again reiterate, it was a collaboration, it was a partnership, and I believe that the plan is much better than when it was initially submitted as a result of that collaboration.
That's great. Thank you, Ms. Ruby. Much appreciated. Commissioners, any questions for Ms. Ruby? Seeing none, is there anyone else who wishes to speak on this matter? Planning, we have anyone else? Nope. All right, we are good to go. Let me turn back to Mr. Haller just to see if you have any closing remarks.
No, thank you, Mr. Chairman. I have no additional information to add.
Okay, thank you. So we'll consider this public hearing to have been held under deliberation. Commissioners, anything else that you want to add or know or think about? And if not, I would look for a motion.
Mr. Chairman, I would like to also congratulate everybody involved. It's a phenomenal project and glad to see it moving forward. And with that, I move that we adopt the findings of staff and approve DSP-22023 and TCP-2-009-2023, along with the conditions as outlined in staff's report and as further modified by applicant exhibit number 1 and as further modified by staff exhibit dated 5/17/23.
Second.
We've got a motion by Commissioner Washington, a second by Commissioner Giraldo. Under discussion, I would only say, Mr. Black, it must be a good day when you don't have to say anything and you're about an inch away from having your project approved, right?
I'll only chime in to say that I wholeheartedly agree with that.
Excellent. Commissioners, any other discussion? If not, I will call the roll. Commissioner Washington.
Vote aye.
Commissioner Giraldo.
I vote aye.
Commissioner Dorner.
Aye.
Vice Chair Bailey.
But I.
I vote aye as well. The ayes have it 5-0. Thank you all. Ms. Black, Mr. Haller, Ms. Silverman, Ms. Ruby, Ms. Lockhart. Thank you all very much.
Thank you for your time and consideration today.
Thank you.
Thank you. Commissioners, do we need quick break, 5-10 minute break, or we're okay to proceed?
Proceed.
Proceed. Okay. All right. We're on to item 6, zoning map amendment ZMA 2022-003, Smith Lake Estates. We have Mr. Tedesco, who will be representing the applicant. We have Ms. Lockhart, who will give the staff presentation. We're going to hear from Mr. Hunt first, because this is newer to us. And so we'll get a little overview of the process. Before we do that, though, even though this is a recommendation to the council, we're still conducting this as an evidentiary hearing. So I'll be requiring those intending to provide testimony to take an oath as well. So at this time, I'll ask all persons intending to provide testimony, if there are any. Mr. Tedesco, do we have folks on your team who will be speaking, who need to be sworn in?
Mr. Chairman, we have folks from the team here. I don't anticipate they'll need to testify, but just in the abundance of caution to not delay things, if they should have to answer a question, why don't we have them queue up and just take the oath? And
okay. We've got a bunch of members of the team. If the members of the team could jump on, and we'll swear you in just in case. Give folks a minute or two. I think I see 6 members of your team here just in case. I don't know if they're all here. We'll take the 3 that you have. So folks, if you could raise your right hand. You solemnly swear or affirm that the testimony that your testimony will be the whole truth and nothing but the truth. Yes?
I do. Yes, I do.
Okay, thank you. Consider yourself sworn in. Thank you, Mr. Tedesco. So now we'll go back to staff. We'll start with Mr. Hunt, then we'll hear from Ms. Lockhart. But Mr. Hunt, tell us about this exciting thing that we're taking on.
Yes, good morning, Mr. Chair, members of the Planning Board. For the record, I'm James Hunt with the Development Review Division. As this is somewhat of a historical moment for the Planning Board, I'd like to provide everyone with a few points of reference regarding the Plan Development Zoning Map Amendment process, which is a part of our brand new zoning ordinance. In the current zoning ordinance, there are about 7 different Plan Development or PD zones. These PD zones replace the comprehensive design zones, which everyone is more accustomed to from the prior zoning ordinance. More specifically, the Residential Plan Development or RPD zone provides flexibility regarding the design and mix of residential use types within planned residential communities. This particular zoning may incorporate supporting and complementary non-residential uses to serve the needs of the residents of the development. Lastly, it's expected to incorporate comprehensive pedestrian and bicycle circulation networks, often separating them from vehicular roadways, as well as integrating open spaces and amenities within and adjacent to the overall development. As a matter of process, the PD zoning map amendments, they don't have a set time in which the Planning Board must make a recommendation. The Planning Board may elect to review staff's recommendation and may make their official recommendation at basically an upcoming Planning Board meeting. They can do that. As a part of the consideration, the Planning Board's recommendation must address 4 things. And those 4 things are, number 1, whether the application complies with section 273602C, which is the Plan Development Decision Standards. 2, the need and justification for the PD zone. 3, the effect of the PD zone, if any, on the land subject to the proposed PD and other surrounding neighborhoods. And then 4, the relationship of the proposed PD zone to the purposes of the ordinance, the general plan, and the applicable area master plan or sector plan, with appropriate consideration as to whether the proposed PD zone will further the purpose of this ordinance, the general plan or that plan itself, the sector plan or master plan itself. The Planning Board may elect to recommend revisions to the PD basic plan and PD conditions of approval. Per section 273602 of the zoning ordinance, the Planning Board can only make a recommendation that is to be transmitted to the zoning hearing examiner. The ZHE will hold a public hearing within 100 days of receiving the Planning Board's recommendation. Afterwards, the ZHE will transmit the complete record to include both the Planning Board and the ZHE's recommendation to the District Council for a final decision. If you have any further questions, staff is available. Otherwise, I can turn it over to Dominique to provide you with a presentation on the Smith Lake Estates request.
Before we hear from Ms. Lockhart, let's stay with Mr. Hunt a bit, commissioners. I just want to make sure that we're all clear around what this process that is before us, because there's a way in which we have a bit of an enhanced role that I think is helpful for us to think about. And correct me if I'm wrong, Mr. Hunt, but I mean, in a sense, we're granting the right to move ahead with this plan development in exchange, because the assumption is it is a superior development, and then the benefits that come with it will be superior benefits as well. I mean, in lay terms, that's what we're looking at here, right?
Absolutely, because in this particular situation, the property is zoned RR, and then the applicant, of course, there are certain development standards that are out there. However, relevant to the PD zone, PD residential zone, staff is making a recommendation. The applicant actually is putting in a recommendation on different changes to that in order to support their density request and anything else they really want to do. So that being said, their request is supposed to be superior than what's already set as the standard for that RR zone.
So there's a fair degree of flexibility that is going to be provided in exchange for, again, some nice benefits and what will essentially be the superior development and the superior amenities. So that's what we want to look at. In addition to the things that we would typically look at, does it adhere to this? Does it adhere to that? We want to see if we think this rises to the level of the additional flexibility that's being offered.
Absolutely, because this is going to set this right. This is going to set the stage for everything moving forward with the preliminary plan of subdivision, as well as with the detailed site plan that's going to come forward.
And so I've asked staff, and this will be a work in process, and I'm not sure we're going to get the full flavor of this on this staff presentation. But as we move forward with these, we'll be looking for staff to articulate to us exactly the ways in which this superior development, that the superior benefits are being provided, and to have staff be clear about that, as well as talking about ways in which there may be some negative impacts and how they're being mitigated as well. So the report may, as we move down the road on these ZMAs, the reports may feel a little bit different, so that they're giving us the ammunition we need to make a slightly different decision. Okay. So, commissioners, questions about that? Is that clear enough?
Yeah, it's clear for now and very helpful. I guess just checking my procedural understanding. So we are recommending approval to the ZHE, which then the combined recommendation would go before the district council, or go to the district council from the ZHE. Is that right?
It's a recommendation to the zoning hearing examiner, which they're going to hold a public hearing to get additional public input as well at that point in time. That will eventually, like you say, go straight to the district council for that final decision.
So there are 3 public hearings. And in fact, we would be holding one today if people signed up to testify on this, right?
In that sense,
and then the ZHE, and then finally the district council. Again, because we're all considering something that is supposed to be much superior to what we've been dealing with before. Not to oversimplify it, but.
Absolutely. This PD zoning is allowing the county to look at these areas and to provide, like you said, superior development here, superior standards, things like that. That's what we're really looking for, to have a better, high quality development, which is what this new zoning ordinance that that has been adopted is intended to do, and to provide you all, the planning board, the flexibility to provide your feedback as a part of that process.
No, that's good. It's exciting. Thank you, Mr. Hunt.
Yeah, and keep in mind that many jurisdictions around the country, around the region, around the country, have these kind of plan unit development processes. It's a very healthy, robust process, and I'm glad that through the zoning rewrite, we now have the opportunity to take this up as well, and really can lead to some much higher quality, superior development in the county. So I'm happy about it. Commissioners, any other questions for Mr. Hunt?
The question that I have, and I guess at this point it's probably not an issue, but what about the recent legislation that the council passed stopping townhouse development except in TDZ zones? So how does this factor in?
So the question, if I'm interpreting it correctly, if the council has not passed it, by the way, they have it's actually on hold right now, but they're still in conversation about it. But
Right.
if it were to have passed, would we be able to approve townhomes in a PD zone if the council passed that, or would that preclude us from doing it if it's not in one of the targeted
Right,
areas?
that's my question. If the council goes ahead and does that, yeah, that's what I'm trying to figure out. Or is that not an issue at this juncture?
It's not an issue. I'm going to leave it to David to kind of, let me turn it over to David to kind of answer that aspect of it. Sorry.
All right, thank you, David Warner, Principal Counsel. At this juncture, it's not an issue. Of course, if this goes all the way to the district council and they approve the zoning to this plan development with its proposed uses, then the district council would be approving the townhouses proposed in this legislation, and that would go forward.
Okay, thank you.
All right. Any other questions for Mr. Hunt, Mr. Warner?
Yeah,
If not, we'll get substance. Yeah, Commissioner Dorner.
so just for clarity, when we're handling this case, this is just a rezoning from the existing R zone to the RPD zone for this particular property. So anything that we describe in terms of our recommendations to the zoning hearing examiner is specifically going to pertain to this RPD zone for this particular property, and not for RPD zones for other properties, right?
That's correct.
Okay. So my understanding is that this is essentially like, in more colloquial terms in other jurisdictions, which would just be like a planned unit development, where you're kind of erasing the zoning that's existing on the particular property, allowing more customized zoning or customized kind of specifications for this specific property that just gives it a little bit more flexibility.
Correct.
Okay, all right, thank you.
Yeah. Okay, no further questions. We'll get into the substance of it and we'll turn to Ms. Lockhart and take it away.
All right, thank you. So good morning again, Chair Shapiro and members of the Planning Board. For the record, I am Dominique Lockhart with the zoning section. Item number 6 on the agenda is zoning map amendment ZMA-2022-003 titled Smith Lake Estates. This application consists of rezoning the subject property from the residential rural zone to the residential planned development zone. As a matter of housekeeping, staff would like to note some technical corrections to the staff report. The staff report refers to the future detailed site plan phase as DSP. The new abbreviation for a detailed site plan for the current zoning ordinance is DET. That correction will need to be made on pages 18 and 20 of the staff report. In addition, the language referencing the need for a comprehensive design plan on page 15 of the technical staff report will be removed, as a CDP is not required. And lastly, reference to the Boys Village of Maryland will be changed to the Cheltenham Youth Facility on pages 4, 7, and 11 of the staff report. Next slide, please. The site is located in Planning Area 82A in Council District 9. Next slide. More specifically, as outlined in red, the site is located west of Frank Tippett Road, approximately 600 feet from its intersection with Como Road. Next slide. The site is currently located in the RR zone. Under the prior zoning map, the site was also zoned rural residential. Next slide, please. The subject property is not located within an overlay zone. Next slide. The aerial photograph shows the subject site is currently wooded and undeveloped. Next slide, please. The topography map shows the site contains moderate slopes throughout the property, especially toward the northwest property boundary. Next slide, please. The property is adjacent to Frank Tippett Road, as previously stated, which is a collector roadway. Next slide, please. Here is a closer bird's eye view of the undeveloped site outlined in blue. To the north and east of the site are single-family detached homes, and south of the site is the Cheltenham Youth Facility owned by the state of Maryland. Next slide, please. Okay. This slide shows the proposed basic plan showing the 62.52 acre site. The net tract area of the site is 60.01 acres after removing the area of the floodplain. The Subregion 6 Master Plan and SMA recommends residential low land use on the subject property. Residential low is described in the SMA as residential areas made up of primarily single-family detached dwellings. The subject property is currently zoned RR, which allows density of 2.17 dwelling units per acre, which would result in 130 single-family dwelling units. The RR zone currently does not permit townhouse dwellings. The flexibility of the RPD zone will allow the applicant to include both single-family detached homes and townhouses within the development. The proposed maximum density is 2.5 dwelling units per acre, which will result in 150 dwelling units, which is only 20 dwelling units above what is permitted in the base RR zone. The single-family detached homes will be located in the yellow portion of the plan, as shown, and the townhomes will be located within the purple portion of the plan, as depicted. Next slide, please. Thank you. This slide shows the circulation plan for the development. The site will be served by one access point from Frank Tippett Road and will include an internal street and sidewalk network for pedestrians and vehicles. Adequacy will be determined in subsequent applications. Next slide, please. This slide shows the open space set-aside exhibit. The site contains environmental constraints, including streams, wetlands, and floodplain areas as detailed on page 7 of the staff report. The proposed development is an environmentally sensitive design that protects the various environmental features of the site. Approximately 22 acres, or 31% of the site, will be set aside as open space in accordance with the development standards in the zoning ordinance. Majority of the open space is preserved for woodland conservation, and the remaining areas will be for active and passive recreation. Park areas, a playground, a trail circuit, and sitting areas around the existing pond will be some of the amenities provided and detailed in future applications. Next slide, please. Staff recommends that the planning board adopt staff's recommendation of approval with conditions of zoning map amendment ZMA-2022-003. This recommendation will be transmitted to the zoning hearing examiner prior to being heard by the district council. And this concludes staff's presentation. Thank you.
Thank you, Ms. Lockhart. Questions for Ms. Lockhart, commissioners? So I just have one, and this is for you, Ms. Lockhart, Mr. Hunt as well. Run me through, and pardon my ignorance, but run me through the process with this. What are the additional stages where we're going to get into more details? We talked about the DET. That's the next time we will see, assuming we support this and ZHE and the district council. When next we see this is at the DET stage, is that right?
Yeah, so there will be a preliminary plan of subdivision followed by a detailed site plan.
I thought you said there was some correction to the acronyms.
Yes, so in the staff report, I reference a detailed site plan phase as DSP, and that's no longer the acronym in the zoning ordinance. It's now DET.
So it's preliminary plan, then DET, not D, you said DSP, but it's DET.
Oh, did I say it again? I'm sorry.
Yeah, okay.
Thank you. Because I'm trying to get a handle on, and I'm just thinking about, I'm having a conversation with us, trying to figure out our process. At what point do we get to the level of detail where we need to start thinking about the superior benefits and the amenities and all those things? Are we going to see, we'll see pieces of that at preliminary plan, and then we'll see even more pieces of it at DET? Is that the idea? And if so, is there anything, James, Mr. Hunt, is there anything that we should be looking at this stage of approval? You know, what should we be flagging? So we're thinking of this slightly differently, if anything.
It's more at, I'm sorry, for the record, James Hunt with the Development Review Division. It's more at this point in time regarding circulation of site, what the planning board wants to see with this development, circulation of site, pedestrian improvements that will be further reviewed later in the stages of the development process between a preliminary plan and detailed site plan, access, various other aspects of those further stages that you all want to see later on, whether, you know, they've already kind of indicated to everyone what the max amount of dwelling units that they are looking to provide for this development. Now, I guess at this point, you know, what exactly does the planning board want to see that you all would consider to be superior than what would be typically provided at the time with our zone property? So various aspects of, you know, the development, the locations of different things. Typically, you know, prior to this, you know, you can kind of think of it like at the time of under the old ordinance as a comprehensive design zone. Think of it those kind of like bubble plan type situations where you're trying to, you know, find out how much access you want to see on the site, relationships between different areas of the site, what you would want to see moving forward, what you all would consider to be a higher superior development, utilizing the information the applicant's proposing here. So that's kind of like what we'd be looking for at the time. You know, we obviously at the time of preliminary plan, testing for adequacy at that point, and then going to a lot more detail with what you've requested or provided as a standard with this zoning map amendment at the time of
So, I mean, at the end of the day, a lot of this is going to come at the DET stage.
Right.
Yes, design-wise, landscaping, that's going to be like we typically find at the detailed site plan stage. We're going to really be looking at, of course, adequacy to only at the time of preliminary plan. And any applicable conditions that you all provide here with this zoning map amendment that are going to be applicable to that preliminary plan stage. Staff will be reviewing to ensure in conformance with those conditions at that time.
Mr. Flanagan, can you pull up the slide that shows the sort of the bubble plan? Right. So really, at some level, the only thing we can be looking at right here is this, because that's the only sort of level of detail around it. Or maybe there was two slides later. Go slowly on that right there. I mean, there's a little bit here. I mean, what I guess, and we'll hear from Mr. Tedesco and maybe other members of the team. But the only thing that I'm paying attention to in this at this stage, I think, seems to be what the orientation of the development is to its natural environment, and especially this. It's a stormwater pond. It's not a natural pond, right? But it still feels like. Is it? Do we know? I don't even know. Is it natural or is it stormwater pond? Or what?
I had the same question. I was wondering.
Even
there's something about. You think it's natural? Because there's something about this thing's orientation toward it, where this feels like the central feature of this development in lots of ways. And so how is that accentuated? I'd be curious about that, Mr. Tedesco, when we get to you. And same with some of the other natural areas. So, but again, a lot of this feels like we're going to get into it at preliminary plan and DET, not here.
That's correct. We're looking here, you know, just look at pedestrian bicycle circulation networks, ensuring that that's incorporated in here and reviewed. That will be reviewed later on. Also with these various vehicular roadways, how do those roadways interact with, let's say, pedestrian? If you don't have a trail, where the trail is going to be located, we'll further look at it there, and also integrating open spaces and various other amenities throughout the development.
But we don't have that detail here in front of us.
Right. Just saying, you know, if you all would want to see that moving forward, these are some of the things you would want to be looking at. And I think staff at this point in time, staff has been reviewing for that, and will be, you know, we've placed conditions in here, and also the applicants proposed a pretty good proposal here with what they're recommending to do with this application. And so we've reviewed and coordinated with that, and we're finding, you know, we're recommending approval with conditions in here as well.
Right. I mean, I'm again, pardon me, commissioners, I'm just sort of talking through based on my experience, even my experience in DC and how I'm thinking about this. In DC, what would typically happen is we would be looking at planned unit development along with a map amendment, along with the zoning change, so that you can evaluate whether or not it makes sense to grant the zoning change in the context the entities that you're going to see in the is that something that we would consider through our processes? Are we even allowed to do that through our processes?
I'll turn that over, let Mr. Warner speak to that aspect of that.
Sure, David Warner, Principal Counsel. So I think the best way to describe this plan development process is, one, to think of it as all of the requirements that you would normally see in a Euclidean zone. What are the minimum lot sizes? What are the minimum requirements for all the different uses that you're going to permit? Those are kind of the conditions that we're setting. But then in addition to that, because it's a plan development, it comes along with a basic plan, the one that they showed there on the other slide. But the basic plan is very general. If you look at the standards on pages 12, 13, 14, and 15, it kind of gets at what the planning board can look at this time, which is very generalized layout considerations, general design and layout of the on-site transportation, and where recreation is going to go, where open space is going to be, very generalized at this stage. And then, yes, we get to the preliminary plan stage. Now we're evaluating adequacy of all the different sections that are going to be developing. And then the physical development of the property will be evaluated at the detailed site plan stage. Now that's where we get where the building's going and all of the other physical pieces. So it's kind of the three-step process in that way.
Yeah, but my question is, because it makes it hard, I'm only thinking my own experience of this. It makes it hard for me to justify the zoning flexibility without a sense of, well, what are we getting for it? Because the what are we getting for it piece isn't going to come till later. So is it possible, and Mr. Tedesco, I'm totally with you, and I want to bring you into this conversation, so for sure. But I'm trying to figure out how do we,
Mr. Chair,
yeah.
I'm struggling the same way as you are. I'm trying to figure out, how do we determine at this point whether it's superior or not to be in the RR? So what is going to be brought to the table to make it superior so that we can recommend the zoning amendment? I'm kind of struggling. I don't see anything on this plan that makes it better than the RR, other than they're able to put another 20 or 25 houses. So I'm trying to.
I'm with you. Let's actually bring, because I think Mr. Tedesco will probably help us to be part of this conversation. So let me move on to the next thing. Let's bring him in and let's include him in the conversation, commissioners, if that's okay with you all. So, so Mr. Tedesco, we have nothing else from staff, no other questions for now. So let me turn to the attorney who's representing the applicant, Matt Tedesco. Take it away.
Good morning, Mr. Chairman. Can you hear me okay?
Yeah, we can hear you fine.
Thank you. Good morning, members of the planning board, members of staff. I want to real quick just thank staff for its review of this application. Of course, all best plans get thrown out the window once we kind of get into these cases, and I had a very nice detailed outline that I was going to go through and take everyone through. And I guess not surprisingly, but a little unexpectedly, we've kind of diverted a little bit in the conversation. However, understanding the importance of it, and I will have to continually update my resume, because I guess I am the lucky one that always gets the case of first impressions, as we say, more often than not. So, but I do appear before you this morning on behalf of D.R. Horton Incorporated, who is the contract purchaser and applicant of the subject property. The property is owned by Walton and its affiliates, and is part of an overall bigger development scheme with respect to some of the Walton Holdings and D.R. Horton. Many of those projects in Brandywine and Westphalia that we have presented to you all. This is another iteration of that. As Mr. Hunt indicated, this is a new process under the new zoning ordinance. It is a new zone. When the new zoning ordinance was prepared and ultimately adopted through the countywide map amendment, there was a recognition at that time that the standard Euclidean zones are a little too restrictive and prioritize adherence to standards over form, function, quality, and design. The best analogy of these new PD zones is the prior comprehensive design zones, for which you all have a tremendous amount of experience reviewing. And Mr. Warner hit on those when he referenced the prior zoning ordinance in relation to our CDZs. We had to do CDPs, comprehensive development plans. We no longer have CSPs or CDPs. We no longer have the comprehensive design zones. What we do have are these planned development zones, industrial, residential, mixed use, et cetera. And what they seek to do is provide flexibility. And I know the board has been throwing around the term superior to. It actually is not a superior to any other standard per se. If you read the purposes of the PD zone, one could draw the conclusion, well, that results in a better project. Is there a test that I have to prove before you and you all have to determine that this is superior to anything else? No. And your staff report does an excellent job, and our justification statement does an excellent job of laying out the required decision standards as well as the recommendation parameters that the board has to take in reviewing this case. We believe, and your staff believes, that this rezoning to the PD provides the ability to present a development that in your terms would be superior to a Euclidean RR zoning. There's many reasons for that. Primarily, the PD zoning, as it intended to do, creates flexibility in design standards. It creates flexibility in uses that we otherwise would not be able to achieve in the RR. Now, if I take a step back, this case kind of brings me full circle. This is one of the first cases I worked on 18 and a half years ago when we did the first preliminary plan for it under the then RR zoning, and it yielded around 60 lots because of the environmental features, because of the design standards. Again, those onerous design standards that really the PD zones and the new zoning orders are getting us away from. It provides the flexibility for us to have more compact development so that we can preserve environmental features. That's a buzzword for superior. We can preserve all these environmental features on site while providing the density that's envisioned in your planning documents, both the general plan and the subregion 6 master plan. That's the threshold question for these PD zones. Is it in conformance or consistent with the planning documents? And this absolutely 100% is. It's low residential density. Under the general plan and master plan, that's 3.5 units to the acre. This is no more than 2.5 units to the acre. The base RR zone is, the base RR zone, I believe, is 2.17 units to the acre. So we're right within the density parameters that's allowed. Now, what it also does is it provides us the flexibility to have various product types. And why is that important? And again, that goes in the column of quote unquote superior. Not only does it allow for us to provide high quality, but it creates opportunity to provide unique mix of housing types consisting of both single family detached with varying lot sizes and the inclusion of wider attached units. Now, we specifically in our justification statement use the term attached units. Staff uses the term townhomes, both of which are correct, but I do want to make a clear line of distinction between the two. They're attached units because we have quote unquote sticks of more than 3 units. Their staff has considered them townhomes. We acknowledge that. However, for this development, and you can see from that proposed lotting pattern, it's not your prototypical townhouse. What we're proposing here are single family detached and villas. Those villas will consist of 26 foot wide to 32 foot wide, typically 2-story houses. Now, why is that important, or why is that superior to its standard RR zone? It's directly responsive to the current housing issues that are currently plaguing the county. For example, in March of 2023, just 2 months ago, month and a half ago, there were approximately 798 active listings for residential homes countywide. Compare that to 4 years ago, there was more than 1,600 listings. We are embarking upon or in a housing crisis in Prince George's County. Whether some of our elected officials want to acknowledge it or not, that's the reality. The combination of single family detached and attached villas, which these are villas, at typically 2 stories, 26 to 32 foot wide, provide a mix of housing types envisioned not only by the zoning ordinance and for the RPD developments, but is 100% consistent and responsive to the housing opportunity for all, the countywide housing strategy from 2019. Moreover, the inclusion of villas is responsive to the needs and requests to offer products that allow residents to age in place and providing various price points. Again, something we could not do under the RR zone. Please add that to the column of Superior. Therefore, the applicant seeks the rezoning to the RPD zone to take advantage of the new zoning ordinance, the goals and visions of the master plan, policies and guidelines, as well as the general plan. Indeed, on this particular case, we've been working with staff on this since late 2021 into 2022, prior to the adoption of the countywide map amendment and the implementation of the new zoning ordinance as a test case. So we've worked very closely with your staff for more than a year and a half on this particular case, predating even the implementation of the zoning ordinance. And you have a thoroughly, and I want to thank Ms. Lockhart and all of staff for the review. Every agency, every department has recommended approval. Ms. Lockhart's done a fantastic job of going through each of the elements. The justification statement we incorporate and adopt as further testimony. I go through each of the elements on why the RPD zoning creates, again, quote unquote, a superior product than what the RR zone could allow us. It provides the flexibility in design and product types. With supply low and prices high, the RPD represents an opportunity to include density that is consistent with the planning goals and policies, while also providing the ability to have different offerings as far as products and prices. The RPD allows for a more compact and inclusive residential development that is responsive and works with the existing environmental features of the property. The RPD zone allows the ability to design around the site's existing environmental features, thereby creating an environmentally sensitive design that preserves and protects the environmental features on site. This is also consistent with the anticipatory climate action plan that the county is pursuing. Simply, the request of rezoning on the property to the RPD zone will allow for a more efficient use of land and higher quality development while respecting and preserving environmental features on site, while being consistent with the surrounding neighborhood and character of the existing area. Again, all those findings are included in your staff report as well as the justification statement. And again, after all, commissioners, the PD zones were established and are intended to encourage innovative land planning and site design concepts that support high quality development, preserving the environmental features, and while giving property and developers flexibility to accommodate the vision and the goals of the master plan and the general plan. The PD zone reduces the inflexibility of zone standards that often result from strict application of the base zone standards, which is what's plagued this project for 18 years. In conclusion, I would just again refer you to the specific recommendations on your staff report at pages 6 through 7. Those go through your recommendations as far as the planning board addressing certain things. Not necessarily have to make certain findings, but certain things are addressed. All that's articulated in pages 6 through 8 of your staff report. At pages 8 through 10, it goes through the specific decision standards that the district council will ultimately have to make, although as part of your recommendation pursuant to 273602B7A, the board the recommendation shall be in accordance with 273602C, and 273602C decision standards are on pages 8 through 10. With all of that being said, I know that was a mouthful. I'll just conclude by saying, in accordance with section 274301D1A and 4302A2, the application is consistent and furthers the goals, policies, and visions of the Subregion 6 Master Plan and SMA and Plan 2035. The development proposes densities consistent with the recommended residential low land use of the master plan and SMA, and the proposed uses of single-family attached homes and villas attached units are of similar character to the surrounding community and are context sensitive as prescribed in Plan 2035 for the properties in the established community growth policy area. I would just conclude with the one question regarding the existing pond. That is a man-made pond. It's a farm pond. It will be converted as for storm water. It will become an amenity at the time of the preliminary plan, at the time of the detailed site plan. It will be amenitized with its trail system, as well as other features to make it a central feature. And the purpose of this plan, not only to show the additional open space set aside that we're able to achieve, while also achieving the density envisioned in the RR zone, saving the onerous, inflexible zone restriction or regulations of the RR zone, we're able to create a central feature while preserving all the existing environmental features and woodland. But as you pull in, as we envision it, as you pull into the development, that amenity, that feature will be front and center. There'll be single family detached homes fronting on it. The villas are envisioned along the entry as you enter the site to the south. And everything will be connected through walking trails and sidewalks. Again, much more detailed information on that in the coming applications. But from a superiority standpoint, this is far and away superior. And it really is the poster child for the PD zonings, which is, I think, why your staff is so has been so consistent with working with us and recommending approval of it, because it does result in the ability to meet the purposes and intent and policy and guidelines of the plan and the zoning ordinance, while maintaining the character of the area and being able to better preserve environmental features. So with that, Mr. Chairman, I'm sure there's questions. I'm happy to answer them.
You're
Yeah,
muted,
Ms.
Mr. Chairman.
Sorry, folks. I just said thank you, Mr. Tedesco, and I just want to say I found that very helpful. So commissioners, questions for Mr. Tedesco?
Well, I'm still kind of stuck on the process, because I don't know if we have enough information yet to meet what it says is that the health, safety, and welfare of the future inhabitants of the development will be protected and promoting by providing high-quality development that features both passive and active recreation amenities. So I'm saying I don't see how we arrived at that conclusion, or can arrive at that conclusion at this stage, unless we see more and we get some commitments at this juncture.
Where are you reading from, Commissioner?
I'm reading on page 7. Item 4. So how do I make that determination? I mean, you're going to, the pond is going to have to stay there anyway. If you just keep it at the R, and I'm just trying to understand the process and the procedure to get to that point. I mean,
I'm not seeing where you're reading from. On staff report, page 7, item 4 is the relationship of the proposed PD zone to the purposes of this ordinance.
Right, and then look underneath, the proposed RPD zone will further the purposes of this ordinance, the general plan, and the area master plan. The health, safety, and welfare of the future inhabitants of the development will be protected and promoted by providing high-quality development that features both passive and active recreation amenities. That's what I'm reading. So how do I get there based upon looking at this map? I mean, if I understand, okay, you're going to get another 22 houses, right? The pond is already there. It's going to be there. What? I don't see what you're doing differently than if you were just putting up 22 houses, 120 houses.
Yeah, with all due respect, Commissioner, that's the issue with the base zoning and the problematic with it. If strict compliance with the base zoning, you don't have the mix of housing type, so you don't have the ability to have age in place. We're stuck with 20,000 square foot lots and 100-foot lot widths. The density goes down, so you don't have the ability to have compact development. You have more environmental impacts than otherwise we can preserve through a more compact development. the policies and goals of the master plan are through the established communities, which is outlined in your referral from countywide planning, as well as your staff report, to provide context-sensitive development at 3.5 units to the acre. I can't even achieve that under the RR base zone because of the other inflexible regulatory parameters that exist. So when you talk about the relationship of the proposed PD zone to the purposes of this ordinance, the general plan, the applicable master plan, staff has 5 paragraphs of findings, and with respect to that, the mix of dwelling types proposed will enhance the established character of the surrounding residential communities and provide options for families of various sizes and various price points. The development also ensures the provision of open space to protect the scenic and natural features surrounding the site. The required open space.
Mr. Tedesco, hold on a second. Tell us what you're reading from so that we can read along.
I'm reading staff's finding on page 7 and 8 under item 4.
Okay, keep going.
The set aside amount is 20% of the development area. That's the requirement. We're proposing 31%. Then it goes into all the several policies outlined in Plan 2035 are furthered by this is page 8, top of the page. Further proposed by the development, one of 6 principles that guides Plan 2035 vision is the concentration of future growth. The proposed development is utilizing the flexibility provided in the RPD zone to create compact residential community while simultaneously preserving the site's existing environmental features. The existing pond will be used as a stormwater management facility and as an amenity. The pedestrian pathways will surround the pond and provide active recreation. In addition, policy 4 of Plan 2035 states, quote, phase new residential development to coincide with the provisions of public facilities and services. Then it goes through the site being in the water and sewer category 3, being in close proximity to existing parks, being within close proximity to fire stations and police stations, and then further schools. So
all of that would be there, Mr. Tedesco. All of that would be there if you keep it at RR. I mean,
I can't, but Commissioner,
excuse me, I'm speaking right now. Excuse me. What I'm saying is that I don't see how this change does anything to promote the health, safety, and welfare. Everything that's been said, we're dealing with conclusions. So what I'm saying is, give me some commitments now, so I could understand that in fact the zoning change should be made. I mean, if you put up the number of houses, the stormwater management is going to be there. We're going to require a trail anyway. You're going to have all of this stuff. So I'm not being difficult. I'm trying to understand how this differs. What are the amenities that you're providing that you would not otherwise have to be provided if you put up a regular development?
I mean, let me jump in. And Commissioner Geraldo, I'm with you. And here's my read on it as I read the information. Where I'm looking at it, the piece that I'm hanging my hat on with this is that essentially this development isn't likely to move forward unless there's some measure of flexibility granted. And what I'm seeing is that the flexibility that we may be offering allows for, again, a more compact style development, which will then preserve the environmental features. And that meets the goals of the sector plan, which is to encourage more development here. I mean, in a nutshell, that's the one thing that I'm hanging on to and saying, okay, that may be an argument for granting the zoning change, because again, compact development, preservation of environmental features, that's at this stage. Now, when we get to preliminary plan, when we get to the DET, there are all sorts of other things that we'll consider. But I'm trying to hang on to, again, what you're saying, which is, okay, but what do we look at this stage? And that's why the one other thing I want to say, and this is, I asked this question at the very beginning, Mr. Warner, I don't think I got an answer to it, which is, I'm more used to, in another life, in another experience, I'm more used to looking at this stage in parallel to the DET stage. So we would actually be looking at a map amendment along with a detailed site plan, so we could hold them both together. Now, do we do that? Can we do that? and this is a question for Mr. Hunt, Mr. Lockhart, Mr. Warner. Are we precluded from doing that, or we're just not used to doing it?
This is David Warner, Principal Counsel. No, we're not at the stage yet where the requirements for a detailed site plan can be considered because we don't have that level. Right.
I'm asking a different question. Can we, can they come to us in parallel?
No, they go in order. We don't bring them. They're not allowed to be brought at the same time.
We are legally precluded from doing that.
Correct.
Well, where is that?
All right.
Just so I know.
Because the order of approvals in the zoning ordinance proceeds, in this case, with the zoning, then the preliminary plan of subdivision, then the detailed site plan.
You mean the
Okay.
DEP?
The DET, right.
So what can we now, Mr. Chair, you finished, or I wanted to have a
Yeah,
follow-up?
that's it. So then
Okay.
if we can't do that, then the only thing is a more flexible compact development is, is superior for this site and actually moves us towards what the sector plan is calling for. So that I get. Not a lot, but I get it at this stage.
So my question is, what can we require now as part of, they're asking for this area to be amended, for the zone to be amended. And I want to know, what can we do as a board as part of that process to require certain things that we know will be in fact in the future, as opposed to coming back and then we come back and then we're going to say, oh, will you make an offer, as opposed to whether or not we can require now.
Gotcha. Mr. Tedesco?
Thank you. Thank you, Commissioner Dorado. Apologies. I think I had a little delay. I didn't mean to speak over you, so I apologize. I think your staff is channeling your thoughts quite well, preemptively, Commissioner Dorado. If you look at the conditions, one of the considerations is that additional areas for passive recreation should be incorporated into the site design, or the proposed passive recreation area should be enlarged and centrally located for easy access to all residents. The project will be required to demonstrate mandatory dedication of parkland at the time of preliminary plan, which may be met through land dedication fee in lieu of the private. So we're already anticipating some of these things with the future applications to get to that point. The other thing I just want to clarify for the record, I know we're kind of going back and forth on section 27-3602B7A Romanet 4 on page 7, and I know you're reading language that I'm just not seeing in the statute with respect to the health, safety, and general welfare under Romanet 4. It's not in the staff report, and I've got the code in front of me, and it's not in the code with respect to that. Romanet 4 is the relationship of the proposed PD zone to the purposes of this ordinance, the general plan, and the applicable area master plan or sector plan, with appropriate consideration as to whether the proposed PD zone will further the purposes of this ordinance, the general plan, and the applicable area master plan or sector plan. I don't think there's any debate that it furthers the purposes of it. I think we're kind of getting tied into what are some of the elements, and I hear you, and we all hear you loud and clear. Given where we are with a basic plan, this is really just a basic plan, and typically the board historically never reviewed basic plans. You all more or less would adopt staff's recommendations and would go straight to ZHE. So I get the nuance of this and the somewhat of the newness of it. But what we do have before you, I think, is beyond sufficient from the perspective of the required findings for 27-3602C as well as B7A as it relates to plan conformance and increased flexibility that provides the ability for this development, as the chairman said, to be compact, meet the purposes of even the RR zone, notwithstanding the inflexible standards of the RR zone, but certainly the future land use recommendation of the master plan by having 2.5 units to the acre when 3.5 was envisioned. So we meet it, that's met from a density perspective, but more importantly, and I need to ring this bell many, many times. This project and this PD zoning allows us to do what we otherwise couldn't do, in my mind, making it superior by providing the flexibility to have smaller lots, even if they're single family detached, as well as a new product that the county really doesn't have a lot of, which are the 26 to 32 foot villas, that allow single floor living, age in place, varying price points. So we check a lot of the boxes when it comes to what is needed from a superiority standpoint, from the housing strategy, and just the world we're living in with a housing shortage in the county. I could not do that under RR. If I was before you with this RR zoning project, it would be not that dissimilar to what we did in 2005, which was 60 some lots and never got off the ground in 18 years. So I can tell you, we know what's going to happen. We know what the options are under RR because it was subdivided. We did 2 subdivisions. We did the detailed site plan. It was ready to go and we couldn't move it forward. This provides us the ability to move it forward and solve a lot of problems that we're realizing in the county. In my mind, making it superior than the base zone.
All right, thank you. So thank you for that. And I also want to recognize that we are constrained by, this is a new process and there's a real opportunity here with plan development, but we're also constrained to Mr. Warner's point where, you know, we don't have the opportunity to approve all the amenities and the level of design detail that we might want, even the bike ped detail that we might want to see at this point. We just can't. But I do wonder, Mr. Tedesco, and maybe this is a little bit of a middle ground, commissioners, as we sort of muddle through this new process. You, Mr. Tedesco, you've alluded a few times to the villa style attached homes and you know, the way in which that's one of the amenities. Even if that approval is going to come at a later date for those sort of design pieces, I think it would benefit us to have some kind of preliminary sketches of what this might look like to help us, because you've fed that to us a bit, but perhaps if we had that, it might help us evaluate how that becomes an amenity that's worth supporting at this stage. And again, I'm trying to find the right balance between, you know, this is not a DET, but can you give us a little bit more detail? I also think, and commissioners, I'm speaking to all of you, I'm fine with moving this forward right here, right now. I really am. I get that the flexibility that's being provided is going to allow the development to happen. I like the idea of the flexibility around lot size and housing type, especially still at a sort of a high level of housing. And that feels to me more than adequate. But I'm curious where you all are to see if we do want more information from him or if we're okay just moving forward as is, given the sort of the basic plan-ish stuff that we're looking at. So where are you all?
Well, I'm fine with moving forward as well. And I thought Mr. Tedesco's comments were helpful and instructive, especially as it relates to the compact and being able to protect the environmental features. And you noted villa, which is something that, quite frankly, I really appreciated in Mr. Tedesco's comments. And I don't know if I'm thinking about it the same way, but having lived in a villa, quite frankly, in the Woodmore community, they're very nice. And I would love to see a lot more of those as opposed to just kind of the stick townhomes that we typically see. It is a much more upscale version, and point well taken, Mr. Chairman. I mean, maybe a visual or at least a description, but that's the visual that came to mind for me. And at the end of the day, quite frankly, you know, the preliminary plan and DET are going to come back before us. And,
Right.
you know, if we don't like what we see at that point, there's still the opportunity to approve or not approve. So.
Thank
Mr.
you.
Chairman, I would like to associate myself with Commissioner Washington's comments because I was thinking that, you know, I'm fine with the basics, that we still have another bite of the apple further down the line, depending on, you know, what happens with this. I don't think this is the final opportunity to have an impact on what's going to happen on this project. So I'm pretty comfortable with where we are. I believe we're just establishing the basic foundation, and that it will come back to us for further discussion.
Yeah, I'm with that. I think you articulated it well, Commissioner Washington. And Commissioner Geraldo, I mean, I've sort of kicked this off by being quite sort of confused about it, like you articulated as well. And I think at some level, it's just the nature of the process that we have before us. And maybe we learn from it, and maybe we, as we go through these, to Mr. Tedesco's point, you know, he drew the short straw because it's the first one we're seeing. And you know, we'll make sense of it as we go along, I believe.
So I do have one question. So I hear everybody's thing, and I appreciate Mr. Tedesco's comments. What I'm wondering is, staff only has considerations. It doesn't have conditions. So the considerations are judgmental calls as opposed to something that they would be required to do as a condition. And that's the concern I have. It says there are additional areas for passive should be incorporated into the site design. So what I'm wondering, why isn't that a condition as opposed to just being a consideration?
Let's ask Mr. Hunt, Mr. Warner.
Mr. Chairman, just for the record, James Hunt, Development Review Division. Yeah, this is, I have to had a conversation with staff. However, it is left up to the board if they would like to make this a condition or turn it into a condition. They have the ability to do so with this zoning map amendment. As far as the process and stuff, they can make conditions, add conditions in here at this point. If they so choose, if you so choose.
Okay. And see, I would be more comfortable with that because then it's set out exactly or close to what the things that they have to do. And that would be the basis, the factual basis for us to find that it's a better development. But a consideration is just that, a consideration, as opposed to a condition.
So should we look at which ones we're gonna, assuming we're all aligned with this, should we look at what we are gonna include as conditions, not just recommendations? What are we talking about?
Yeah, I don't have a problem with what Commissioner Geraldo is saying. I guess I would want to hear from staff why it was there a specific reason as why this is a consideration as opposed to a condition?
Yeah.
Yes, hello again. This is Dominique Lockhart with the zoning section. It was put forth as a consideration only because we didn't want to disturb any of the environmental features that were being preserved. So we would leave it up to the applicant to decide the best place for recreation amenity areas to be placed without impacting those areas that are saved.
Okay, but I mean, that could be done. We're not telling them where to put it anyway. We're just saying that they will do this as a condition, and then they can decide where they want to do it.
I mean, I'm okay with it. Mr. Tedesco, your thoughts on that?
Yeah, I'm thinking, I'm listening and thinking as I'm hearing the dialogue, and I appreciate it. I think it makes sense as a consideration because to Ms. Lockhart's point, while it may not say where it needs to go, wherever it goes, it could have the domino effect as far as additional impacts of things that we don't know. That being said, let me just say this. The prior preliminary plans of subdivision, just so you all know, the prior preliminary plans of subdivision approved in 2005 and 2011 under the RR zone had very basic recreational amenities, about $60,000 worth of recreational amenities, the top lot, and things of that sort. This project, we have no doubt, is going to exceed, mid six figures on the recreational amenities package. I'm happy to proffer that at the time of preliminary plan, just for an added layer of comfort, at the time of preliminary plan, we will provide those details of the recreational amenities so that you see that at that time in consultation with the consideration that's already recommended by staff. And we will show more detail than we typically would at the time of preliminary plan with cost estimates, and then obviously detailed site plans when that should be approved, but we can show them preemptively at the time of preliminary plan because we'll have the project further designed at that point. And obviously keeping in the spirit of this conversation and the board's wishes as well as staff's considerations, that may be a good path forward. And we're happy to proffer that at the time of the preliminary plan, we'll provide the details of the amenities associated with recreational facilities, including cost estimates.
That works for me.
Isn't that required though?
Not the details. We just have, at the time of preliminary plan, we just basically have to meet the requirements as far as if it's on-site dedication, fee in lieu, or if it's private, what the amounts would be. So we have a range, and the actual details of those are approved at the time of detailed site plan, but we can go a step further and actually have those somewhat more designed. Instead of just giving a list of anticipatory improvements, we can actually, again, going a step further to hopefully help the commissioners and Commissioner Geraldo see what these amenities look like.
I'm kind of stuck in not the same, but a similar place as where Commissioner Geraldo is, and trying to, and I definitely see your arguments, Mr. Tedesco, about the improvement of like just the style of housing or like the different mix of housing, and appreciate that. But it's difficult when we're going to be recommending a zoning map change for us to be told, oh, don't worry about like the actual design or the actual amenities or these other things, because those will come later. And then, but I still have to find that this is going to be superior to the RR kind of zone, because in some way we have to know how it's going to be superior. So it's kind of a weird stage to be in. I think if we were to make the consideration of finding, and then you do exactly what you just described, then you would be consistent with that finding. Because literally right now, like we don't see anything on the map. So like, if you provide us a little bit more detail of like what is in there and what you're going to be doing for recreational amenities, then that would be consistent with the finding, because there's nothing that's described kind of in here at the time. And I had a couple of other questions I wanted to ask you in terms of like why decisions were made around here or around like kind of the particular bubble map or this design that we're looking at right now. One of them was actually more specific on the villas, since you had brought those up. You mentioned that there was single floor living, but I think it said it was 2-story villas. So I just wanted to find clarification on that, if it's going to be like stacked on top of each other, or if they're just 2-story high but single floor living. And then one of the things that was also kind of striking me as we were kind of talking about the mix of housing is whether or not you could, or if you considered maybe the potential for not just like single unit attached properties, but multiple unit, not multifamily, but multiple unit single family kind of properties where you would have like a 2x2 or a 4x4 closer to the road, the entrance there, so you'd have the density kind of closer to that way. I think that's something that Commissioner Geraldo spoke about multiple times in terms of like affordability and different kinds of projects that you would see elsewhere in the country. It aren't just like sticks that are there, like you can actually kind of weave them in and have some on top of others. Another question I had was on this particular map around the stormwater management pond or lake, however you want to refer to it, why we're not connecting the two cul-de-sacs, instead of having two cul-de-sacs at the top of it, have it kind of like a loop around there. Because in general, like I hate cul-de-sacs. I think it's like an abomination of planning when they started. And it's like one of the worst things that we can do in planning purposes. I realize that in some cases like they're needed. But connecting those, I was wondering if it would be possible. I realize you've got like a purple kind of like natural feature area there, but when I was looking at the aerial, it didn't really seem like it was much of a natural feature. So I was wondering, like, that'll get you a couple extra houses in there. And then maybe you could be able to like increase wooding somewhere else, or even at some stage offer like pedestrian connectivity between the two cul-de-sacs that are going out to like the left-hand side. Because I see the wooding, and I saw on another diagram like the connectivity within there, but I'm not seeing anything about like how people would connect on trails or other aspects that were mentioned in the staff report. And to me, that's part of the superiority, is like creating these connections and these ability to kind of get back and forth that you may not be able to do in the RR, but you can do in this kind of a plan. Even though that would come at later stages, at least giving us like a precursor to that would help me kind of feel more comfortable in making that determination. So I'll leave it at that in terms of like the things that I'm just kind of thinking out loud about.
Yeah, so let me try to take those in order. With respect to the villas, yeah, I mean, think of them, I think Commissioner Washington hit the nail on the head. Think of them, I mean, they're single family, like a single family detached home. They're just attached at the front. They're 2 stories. Floor plans would envision single floor main living, and then obviously additional rooms on the 2nd floor. They're not stacked towns. They're not 2-over-2s. They're not multifamily. They are really that what we see in other jurisdictions quite often, you know, in particular in Anne Arundel County, where you have, you know, housing for aging in place. We really don't have that in the county, which is why D.R. Horton really is excited about this project and bringing that model to the planning board at future dates when at the appropriate planning application. We did look at a variety of things. Obviously, the RPD zone allows more than just single-family detached in towns. It allows multifamily and other types of uses. But in looking at the requirements, the findings, the decision standards, as well as the recommendation findings that you all have to make, one of the things is, you know, the character of the surrounding area. And we just did not feel that that level of product, whether it be stacked or traditional townhomes, the sticks that we're used to seeing, really fit in place here. The villas as a single family attached product at 2 stories meets that better, a much wider unit. Most of the townhome sticks that you all see and approve are 18, 20, 22s, 24s. These are 26 to 32. Again, just a different product than what we've seen in the county heretofore. So we felt, in keeping with the policies and guidelines and decision matrix and standards, that those fit exceptionally well while also offering a variety of product, different price point, making this superior to a base RR zone. With respect to your suggestion on the cul-de-sacs, keep in mind that this exhibit is an exhibit for the open space set aside. The lotting pattern that's shown here is, you know, obviously subject to change with the preliminary plan of subdivision. You're not approving this lotting pattern or recommending. Well, planning board is not approving anything. It's making a recommendation on this application. You're not recommending anything as it relates to this lotting pattern per se, but we did look at all that and we laid it out. The inability to make that connection, we can look into it more, but really it had to do with, again, one of the selling features of the PD zone is environmental stewardship, more compact development. That would require a crossing. That is an environmental feature that would require an impact. I don't know if environmental planning would be supportive of that. And again, this project, really our goal was to create a superior design with respect to how do we preserve all the environmental features, slopes, streams, woodlands, while also providing a mix of housing types and products at a density that's commensurate with the base zone and consistent with the planning documents. And so it resulted in the balance. All these projects have to be balanced. It resulted in the balance of preserving that area to the north. That is the flood area, the flood drain area for the stormwater / pond. And so we just didn't feel like it would be appropriate to have that environmental impact at that location.
Is there, so I didn't realize it was a flood area. Is there a way to have maybe a bridge that would go over it so you'd have like a pedestrian connection?
So we do have pedestrian connections around the pond, and those will connect to those to the streets. You can see that in the diagram. There's a walking trail around the pond that goes across that area. Yes, thank you, right there. And then there's leads that lead out to the streets and the sidewalks.
Okay.
And this is conceptual, but again, we're happy to proffer at the time of preliminary plan to show greater detail of that.
And the connection, I don't see the connections to the end of the cul-de-sacs to the pond area.
There's connections off to the sidewalks to the south, again, conceptually, but we can certainly look into that and provide those connections. Again, at the time of preliminary plan showed that. Again, I think respectfully, and I understand the struggles that the planning board's having this morning, and we are all constrained by the laws that none of us enact. But we have to be mindful that this is a basic plan. It's not the preliminary plan. It's not the detailed site plan. the orders of approval Mr. Warner indicated provides that with each development stage, we get into that further specificity. That being said, I understanding the struggle the board's having, the applicant is happy to proffer that exhibit, a detailed amenities exhibit that shows these types of details at the time of preliminary plan, especially for that one particular amenity and the passive amenities.
Okay, thank you. One more along those lines when we get to it at the next stage, I assume. I'm struck by the lack of connectivity between the natural area 1 next to the 3, the one that juts into the development, the lack of connectivity with that natural area and the pond area. And I'm wondering if there's...
I was gonna say, we have a connectivity exhibit, connectivity per section part 27-6 that's in the materials. There's a connectivity index plan that shows that it's exceeded. It's slide number, you're indulgent, sorry. Slide number 11. So that provides that provides the required part 27-6 connectivity circulation plan index, which is exceeded. Again, if more detailed information can always be provided at the time of preliminary plan, but that's part of the required findings of this basic plan and has been met.
If I ever struggling on this exhibit is like, how do you connect the stars? So like, if you were to go from one star to the closest adjacent star, how do you connect those there? Because that's where I think it's missing. It just looks like this is car centric in this kind of development, and it would be nice. I know it's not required at this time, but since we are having to like figure out superiority of this map and this plan, we have to have something to kind of like hinge upon. And I was looking at just like, how do you think about connecting those 2 stars at like the top left, or even like the stars, like I think you answered part of my question earlier about the pond, with the 2 stars that are to the top of the pond, that there would be a trail kind of running between there and potentially sidewalks going from those stars down to the trail, which would be exactly responsive to that. But for the 2 stars at the top left, is there any connection between them that's planned?
So those stars indicate the connectivity nodes. And so
I realize that. I'm just using it for reference.
I don't think that the zoning ordinance doesn't contemplate necessarily connecting the nodes vis-a-vis through the environment. I mean, we'd have to blow through those environmental features. Again, you can see with the topography, there's steep slopes and a stream there.
But also, let me jump in, Mr. Teska, and Commissioner Dorner as well. I mean, we're not going to get. I hear you. I have a lot of the same questions. We're not going to get answers to these questions from them at this point, right? Because there's all sorts of design things and financial considerations and things like that. So, what I would hope is that you consider these, assuming we move forward with this, that you'll consider these as flags, things that we're quite interested in. You've already suggested you're going to proffer them at the preliminary plan of subdivision. We want this level of detail, and I agree with Commissioner Dorner. I want to see a really, really robust bike ped connectivity plan that makes this more, this compact design more, dare I say, a little bit more urban in design, a little less suburban in terms of its bike ped connections. That feels superior, if I may use that word. But again, I don't think we're going to get it, Commissioner Dorner, others. We're not going to get that now.
Yeah, I don't think we're going to get them that now. I was just wondering if they'd already figured it out, and I would agree that would make it superior in my mind, and that would help me get over to like the early stage. If it was just at all, we're thinking about that, we're going to be doing it. That would, I think, get me closer to that point.
Yeah. All right. So I want to move our process along here. So Commissioner, let me just say, I'm comfortable with moving forward with this at this stage. I think they've heard our concerns. There's all sorts of questions about this process that I'm still trying to get my head around, and we can keep talking about it internally and work with staff and figure out the best way to do it. I'm glad we had this complex and robust a discussion about it, so that we're all sort of quite publicly trying to make sense of it together. I don't feel like I have a totally clean answer yet about how we measure superiority. Again, dare I use that word, at this stage, but you know, it is what it is.
Well,
Um,
I think Mr. Tedesco's proffer helped as well.
Okay. Okay, all right, so then with that, let's try to wrap this up. Is there anything else, commissioners, any other questions you have for staff, for the applicant, for our council, anything? If not, then I would encourage us to move forward with this, and commissioners will look for a motion.
Mr. Chairman, I move that we adopt the findings of staff to include the technical corrections as stipulated on the record by Ms. Lockhart, and recommend approval of ZMA-2022-003 and transmit to the zoning hearing examiner. And that transmission shall also include conditions 1 and 2, in addition to consideration number 1, as well as a proffered condition by the applicant to provide more detailed amenities exhibit at the time of preliminary plan.
Second.
A motion, Commissioner Washington, second by Vice Chair Bailey. Discussion on the motion.
Just a request for clarification. Does the motion for the consideration 1, has that been made into a recommendation, like had been asked about earlier, or is that a consideration still?
It is still a consideration.
Because we want to allow the flexibility from the applicant to figure it out with staff. That's my understanding, right?
Yes.
That's exactly right.
That's my
Because
understanding.
again, right.
All right, I'm fine with that. Okay, Commissioner Joyner, Commissioner Giraldo, any other discussion?
No.
Good to go. If there's not, I will call the roll. Commissioner Washington,
Vote aye.
Vice Chair Bailey,
Vote aye.
Commissioner Giraldo,
Vote aye.
Commissioner Dorner.
Vote no.
I vote aye. The ayes have it 4-1. Okay, thanks everybody. Thank you, Mr. Tedesco, for being the guinea pig on this one. And thank you, staff, for all the work.
Yeah, thank you, commissioners. Thank you. Have a great day.
You too.
Next item on agenda is item 7. Do we need a break now, or okay to continue?
I would prefer to continue.
Okay, all right. We'll muddle through. Item 7, Community Planning Division. We've got 2 issues to take up. These are for Legacy Mixed Use Town Center Design Review Committee nominations. Let's keep staff, let's keep this brief, please. We'll turn to staff for a presentation on this, and then we'll be looking for action. Mr. Sams?
Mr. Chairman, members of the Planning Board, for the record, this is Dan Sams in the Community Planning Division presenting to you the Town of Riverdale Parks nomination for their Legacy Mixed Use Town Center Design Review Committee, as noted in the staff memorandum. Mr. Chairman, I could read the memorandum into the record if you like, or read the names.
Why don't you read the names, but we, just for the record, but we have the backup material, but give us the names and then we'll take it from there.
Certainly, the Town of Riverdale Park has nominated to the Legacy Mixed Use Town Center Design Review Committee Melissa Anderson, Kayla Anthony, Michael Arnold, Sarah Billington, Richard Smith, Alan Thompson, and Jeffrey York.
Thank you. And Brentwood?
And the Town of Brentwood has nominated to their Legacy Mixed Use Town Center Design Review Committee Garrett Bradford, Larry Goff, Stefan Legan, Marcus Monroe, Quiana Taylor, Rocio Treminio Lopez, and Dr. Mary Vetchery Goff.
Okay. Any other backup you want to give us on this? Commissioners, is this adequate? I think we're comfortable enough. Thank you, Mr. Sams, for the brief presentation. Commissioners, what is your pleasure on these items?
Mr. Chairman, I move that we accept the recommendation, adopt the recommendation of staff and confirm the individuals as read into the record by staff and confirm the nominations for 2-year terms for both the Town of Riverdale Park Legacy Mixed Use Town Center Design Review Committee, as well as the Town of Brentwood.
Second.
A motion by Commissioner Washington, a second by Vice Chair Bailey. Discussion on the motion. Seeing no discussion, I'll call the roll. Commissioner Washington.
Vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
Vote aye.
Commissioner Giraldo.
I vote aye.
I vote aye as well. The ayes have it 5-0. Thank you, Mr. Sams. Item 8 on our agenda, extension request for preliminary plan 4-20013 Kathmandu Village. Don't believe there's any issues with this. It's a 1-year extension that's being asked for. Mr. Haller will be representing the applicant if we have any questions, and Mr. Diaz-Campbell will be giving a brief staff presentation. Mr. Diaz-Campbell, take it away.
Yes, thank you. Good morning, Mr. Chairman, members of the board. For the record, I am Eddie Diaz-Campbell with the subdivision section. Item number 8 on the agenda is an extension request for preliminary plan of subdivision 4-20013 Kathmandu Village. This preliminary plan of subdivision approved 30 lots and 4 parcels for development of 30 single-family detached dwelling units. The preliminary plan was approved by the planning board on May 6, 2021, and is valid through May 27, 2023. By letter dated April 25, 2023, the applicant requested a 1-year extension of the plan's approval. This is the applicant's first extension request. If this request is approved, the preliminary plan of subdivision will be valid through May 27, 2024. Staff has provided a memorandum which evaluates the extension request for its conformance to the required criteria for approval of an extension, which are contained within the prior subdivision regulations. The staff recommends approval of the extension request. This concludes staff's presentation. Thank you.
Thank you. Commissioners, questions for staff? Mr. Haller, anything you want to add?
Good morning again, Mr. Chairman, members of the board. Thomas Haller on behalf of the applicant. No, I have nothing further to add. We support staff's recommendation of approval of the 1-year extension. Thank you very much.
Thank you, Mr. Haller. Commissioners, any questions for Mr. Haller? Seeing none, we have no one else who signed up to speak on this, so I would look for a motion.
Mr. Chairman.
1-year request.
I've got Ms. Chair Bailey.
And I second with my apologies for camera being off. I'm just having some connectivity issues.
Okay. So we have a motion by Vice Chair Bailey to approve the 1-year extension. We have a second by Commissioner Washington. Any discussion on the motion? Seeing none, I'll call the roll. Commissioner Vice Chair Bailey.
One point of discussion. I just mentioned that I like the name of the village, and it made me. This is not all related to the case, but it made me recall that just recently, a couple of days ago, there's in the news there was a reference to a Sherpa. He's actually a mountaineer, an expert in summiting. He's gone up to Mount Everest I think it was 26 times. His name is Pasang Dawa Sherpa. So I wanted to point that out. He's not actually from Kathmandu. He's from a smaller village, but I thought it would at least be fitting to mention his recent ascent and congratulate him publicly, even though we don't deal with him much. It definitely made me think about his name and his accomplishments, which is just insanely good. Like summiting Mount Everest 1 time would be quite impressive, and he's done it 26 times.
Right. Yeah.
Amazing. I was
in my discussion, it's not really the case.
No, but I love it. And I was just telling staff I played tennis yesterday and every joint in my body hurts. I can only imagine what he's dealing with. So thank you, Commissioner Warner, for bringing that up. So we have a motion by Vice Chair Bailey, a second by Commissioner Washington. Any further discussion? If not, I'll call the roll. Vice Chair Bailey.
Vote aye.
Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
Commissioner Giraldo.
I vote aye.
Vote aye as well. The ayes have it 5-0. All right. Last, we have 2 items. These are companion items. They're item 9 and 10 our agenda. Detailed site plan 86 DSP 86116-15 Waterside Subdivision Hill Residence. This was continued from March 23rd, 2023 Planning Board meeting. The companion is item 10 our agenda, which is CP 22002. Let me just make sure I got that. Hill Residence Waterside. Yeah. Conservation Plan 22002 Hill Residence Waterside, both continued from March 29, 2023. Mr. Warner, we can take these up together, yes? Okay, great. So we have, this is also will be an evidentiary hearing. We'll have Ms. Lockhart give the staff presentation with Mr. Taub, who's representing the applicant. But for those who will be speaking, I've got 2 or 3 folks who I think are on the applicant's team. We've got one person who isn't on the applicant's team who will be speaking, I believe. So if you come online so I can swear you in. We've got Mr. Hill, and then we have Mr. and Ms. Hill, right? Mr. Hill, do we have Anita Hill as well?
Yeah, she's in and out, but yes, sir.
And we have Ms. Felder. And then we have, who else? John Shianko. Kaushik Bias? No? Okay, all right, those who are here. Again, this is an evidentiary hearing, so require you to take an oath. So I'll ask you to raise your right hand. Do you swear, solemnly swear, or affirm that your testimony will be the whole truth and nothing but the truth? Say yes? Yes? Okay, thank you all. Consider yourself sworn in. We will start with staff presentation. Ms. Lockhart, take it away.
Mr. Chair, excuse me. I'm going to recuse myself from this hearing. I represented Mr. Hill and his construction company a few years back. So I think it'd be only appropriate and for the sake of transparency that I recuse myself from this hearing or this
Okay. I appreciate that, and I think for the sake of transparency, it makes sense to me too. So thank you. So Commissioner Giraldo is recused. You can turn off your mic and camera, and when we wrap up, we'll call you back in. Okay, commissioners, we'll move forward and we'll start with a staff presentation. Ms. Lockhart, take it away.
All right. Good afternoon, Chair Shapiro and members of the Planning Board. For the record, I am Dominique Lockhart with the zoning section. Items number 9 and 10 on the agenda is detailed site plan DSP-86116-15 with companion case conservation plan CP-22002 for Waterside Subdivision Hill Residence. This application consists of construction of a new 2-story single-family dwelling, and there are also 2 associated variance requests for disturbance of steep slopes and woodland clearing in excess of 30%. Next slide, please. Thank you. The site is located in Planning Area 80 and Council District 8. Next slide. More specifically, as outlined in red, the site is located at 8215 Waterside Court, near the intersection of Waterside Court and Cagle Place. Next slide. The site is currently located in the RR zone. Under the prior zoning map, the site was also zoned RR for rural residential. Next slide. The overlay map shows the entire property is located within the Chesapeake Bay Critical Area Limited Development Overlay Zone. Next slide. The aerial photograph shows the subject site is currently wooded and undeveloped. Next slide. The topography map shows the site contains steep slopes throughout the entire property, especially along the rear property boundary where the lot is adjacent to the Potomac River. Next slide. The site is not currently located near any master planned rights-of-way. Next slide. This slide shows a closer bird's eye view of the undeveloped site outlined in blue. North of the site is a single-family detached residence. To the south, the site abuts out parcel A, which is currently vacant and vegetated. Out parcel A is owned by the Waterside Subdivision Homeowners Association and will remain undeveloped. The Potomac River runs along the rear of the subject property. Next slide, please. This slide shows the existing conditions of the site. Lot 7 is one of the 3 remaining vacant lots within the Waterside subdivision. The gray shading represents areas of the site containing steep slopes. Steep slopes are defined as slopes with a 15% or greater incline. Steep slopes take up approximately 32% of the entire lot. Next slide, please. This slide shows the conservation plan and all proposed improvements. A new single-family detached dwelling with a 3-car garage, driveway, and stormwater management system will be constructed. No work is taking place within the primary and secondary buffers with this application. The proposed boat pier will be reviewed and approved by the Maryland Department of Environment. Next slide, please. Okay. In 2004, DSP-86116-11, shown on the left, was approved by the planning director for a single-family detached dwelling on the property. The disturbance permitted on Lot 7 was noted as 8,550 square feet. The plan also shows clearing on the adjacent HOA property in order to properly grade the site and install the needed retaining wall. The permitted disturbance equated to a woodland clearing amount of 40.5%. This DSP is no longer valid, but serves as an example of a development proposal that would overcome the exceptional physical conditions while requiring less clearing than the previously proposed 52%. As shown on the right, the applicant has demonstrated that providing a 40.5% clearing, similar to the prior DSP approval with the same house footprint, would result in the requirement of a retaining wall. The wall would need to be approximately 54 feet in length and contain sections 10 feet high. Developing the site with this retaining wall would disrupt more of the natural topography. In addition, stormwater management facilities were not a requirement with the previous DSP, which now adds to the disturbance area, resulting in additional clearing. Next slide, please. Since the previous public hearing and as directed by the planning board, the applicant and staff have met on multiple occasions regarding the woodland clearing. As demonstrated by the applicant in this exhibit, the revised development proposes a 42% woodland clearing amount. The increased building footprint is a result of the L-shaped design of the house, which is being used to manage the steep slopes without the need for a separate retaining wall. Effectively, the house structure itself will act as the retaining wall. The proposed development also now shows the required stormwater management facilities, which have been moved closer to the dwelling to impact less area. Staff is in agreement with the proposed woodland clearing of 42%. Next slide, please. This slide shows the proposed front and rear elevations of the new residence. Next slide. This slide shows the proposed right and left elevations for the residence. Next slide. Staff recommends that the planning board adopt the findings of staff and approve detailed site plan DSP-86116-15 and Conservation Plan CP-22002, along with the 2 associated variance requests with conditions as outlined in the staff report. This concludes staff's presentation.
Thank you, Ms. Lockhart. And Commissioner, just a reminder, reminding myself and reminding you all, when we heard this before, that the leftover issue was this issue of the percentage of tree preservation, and we sent the applicant and staff back to, dare I say, negotiate this issue, and we set some parameters for them. So I'm glad to see that we now have what is before us as the applicant staff aligned around a resolution to this. So I just want to note that I'm reminding myself, but maybe reminding you all too. Any questions for Ms. Lockhart before I turn to the applicant? We'll turn to Mr. Taub. You're going to be speaking first or only, or I'm not sure, but anyhow, we'll start with Mr. Taub.
Thank you, Mr. Chairman, members of the board. Good afternoon. For the record, I'm Larry Taub with the firm of O'Malley, Miles, Nallen, and Gilmore here this afternoon representing Michael Hill with regard to this application. As the chairman just indicated, I'm aware that there was extensive discussion at the prior hearing on this matter, and I don't want to belabor this matter in going over matters that have been discussed previously. The chairman is correct that the only remaining issue really was the second variance request, as indicated here, from the Chesapeake Bay critical area requirement that there be no greater than 30% clearing on a particular lot. It's suffice to say that a few things are clear. Number one, that there's extensive topographic issues on this property that are not present at other properties. Secondly, that we've got a matter in which I'm aware that the planning board was focusing on the 40.5% clearing in the previous hearing, but I would note two things. Number one, that previous 40.5% clearing from the previous detailed site plan approval that has since expired was based, at least in part, on a clearing a portion of parcel A, the common area. This does not. This only relates to particular lot 7 at issue. Secondly, I would note that, as was noted in the staff report, if we went to the 40.5% clearing, that would still require the retaining wall that would be 54 feet long, roughly 10 feet high at certain locations, and would in effect cause greater harm to the environment than if we could avoid the location of such a retaining wall. This is also caused to actually a great degree by the fact that this lot, the development of this lot, unlike any other lot that has developed to date in this subdivision, will require stormwater management because the developed lots currently had predated the requirement for stormwater management. But we, in the development slot, must attend to that. We've done so. And really the combination of topography, the existence of stormwater management facilities, and the desire to avoid the retaining wall on this property have brought us to the point that we believe that the solution of allowing a 42% clearing will provide a safer situation. And I believe the environmental staff fully agreed that with 40.5% clearing, not only would we have the retaining wall, but it would also make construction here very difficult. And I would point out that the additional very minimal 1.5% difference in clearing will not in reality result in a greater clearance of any trees or anything of that nature. So we do believe that the 42% clearance as requested through this variance now is, I guess you could say the amended request, will allow for a safer, better, frankly, more environmentally sensitive development on this lot, certainly that was previously proposed, and even better than the 40.5% clearance that had been discussed previously. So again, not wishing to belabor the point, that was really the issue at hand, and that is the reason why we landed on 42% clearance. And with that, we certainly would respectfully request. And by the way, I would say that at this point, the applicant we're very pleased to say that we're in agreement with the staff with regard to the recommendation and all conditions. So with that and with that explanation, we're happy to answer any questions, and we thank you for your attention.
Thank you, Mr. Taub. And Mr. Hill, I certainly want to give you the opportunity to say anything if you have anything additional to add. Good to see you again.
Yes.
Anything from you?
Yeah, the only thing I want to add, I just want to just extend my appreciation to especially Ms. Lockhart, but the whole team, Mr. Hunt, Mr. Burke, Mr. Snyder, all of which spent a lot of additional time in meetings, and some of them were quite complicated. We were dealing with some technical issues that perhaps had not been considered before. So I just want to extend a deep appreciation for all that effort and attention.
All right, appreciate the kind words.
Any questions, I'm available.
Okay. Commissioners, again, I just want to say I'm glad that we've come to a resolution on this. It's good to hear. Commissioners, any questions for the applicant or for staff?
I just say
question.
Thanks a bunch for iterating.
I'm sorry, Commissioner Dorner, go ahead.
No, I was just going to emphasize your comments that thanks so much for iterating on this. I'm glad to see that we came to a solution like we were trying to deal with. That makes it a lot easier.
Indeed. All right, there's no one to speak for this. If there is no further questions for staff or for the applicant, commissioners, I'll close the evidentiary hearing, and what's your pleasure?
Mr. Chairman, thanking as well everyone for getting us to this point. I'd like to move that we adopt the findings of staff and approve DSP-86-11615 and CP-22002, variance to section 27-54817B and variance to section 5B-114E5, along with the conditions as outlined in staff's report. And best wishes to you, Mr. Hill, on your new home.
Second.
Assuming my motion goes through.
It's been seconded. You're a step closer to the home. We have a motion by Commissioner Washington, and a second by Vice Chair Bailey. Any discussion on the motion?
Yeah,
Seeing none,
point
I'll
of
call-
clarification.
Yeah, discussion, Commissioner Joyner.
My audio went in and out, so I just wanted to make sure that the second variance was 5B and not 5D. I may not have been able to hear it clearly, so I just want to.
No, it's section 5B-114E5.
Right.
All right.
Yes.
Further discussion, seeing none, I'll call the roll. Commissioner Washington,
Vote aye.
Vice Chair Bailey.
Praises and I. Glad we're over this one.
Commissioner Joyner.
Vote aye.
I vote aye as well. The ayes have it 4-0. We have a recusal. Do I list that as an abstention, Mr. Warner? Or is it the vote is just 4-0?
Just 4-0.
Okay, thank you.
Mr. Chairman, I know this is over. I would just want to say that I was remiss in not also thanking the staff, because this was a difficult matter. And Ms. Lockhart, Mr. Burke, Mr. Schneider, others were terrific in working with us and helping us work through this. So my apologies for not saying it earlier, but we really did appreciate the cooperation and the assistance of the staff. So thank you all.
Thank you. Appreciate that. On behalf of the staff, we appreciate that. All right. Thank you, Mr. Hill. Good luck with the home. Thank you, Mr. Taub. Thank you, Ms. Lockhart, for all of your work today. And commissioners, well, Mr. Hunt, is there any further business before us?
Chairman, there are no additional business items before the planning board today.
Since there are no,
Hey.
hallelujah. Then without objection, we are adjourned. Go enjoy your lunch.
No
Thank you.
objection.
Have a great day, everybody.
Great
Bye.
day.